Mój działa na pewno, tak słyszę.
Dzień dobry Państwu, witam bardzo serdecznie na spotkaniu z sędziami.
Good afternoon, ladies and gentlemen. Welcome to the meeting with Igor Tuleya, the judge. The title of our meeting is really serious about Temida and Utopia. For how many days have you not been in your judicial duty? I have never been good enough in months. Since the 18th of November 2020, I am not a record-breaking person. My friend IUSTITIA is the record holder. Do you understand why it was possible for you to be punished with a disciplinary punishment and be suspended in your judicial duties in the Polish state? No, I don't. I have never expected something like that in my fatherland. During my studies, we were warned that when we are judges, we can be exposed to contacts with the criminals, but nobody warned us that we could be removed from service and that will be treated like that. It's not about the disciplinary proceedings. I am a part of many such proceedings, and I don't hold a record here. But against me, in relation to my adjudication, panel proceedings are carried out. So that is why I was suspended by the Disciplinary Chamber. What does the life of such a judge look like, of a judge who made sentences in very important cases? A judge who does not work, who can't go to court? Are you still a judge or not? Yes, I am still a judge. I am proud of it, and that's how I feel. But in practice, it means I have no access to any documents. I don't have access to the court network. It's all up to my supervisors and heads of the courts who respect the decision of the Disciplinary Chamber, but don't follow the law, meaning the sentences of the common courts and the courts of the European courts. What does my life look like now? Well, it's a difficult question. As every person in a similar situation, I have my own diary. So I think it's going to provide rich material for the future court proceedings. I don't deserve a round of applause, because it was only a joke. The act of indictment, this is not a joke. Who should be indicted and what for? I do agree with Minister Ziobro that there are no holy cows, and people who break the law should always bear the consequences. I do believe that people who breach the law by not following the court sentences will be settled. If these are judges, they will be settled in disciplinary proceedings or other types of proceedings. They will have to explain their acts, observing the basic standards that we are deprived of nowadays. But I do believe that those who breach the law will have the opportunity to explain why they did so. I know, but what actually happened? Where were the rules violated? No. Well, nothing like that happened. Here, I don't wear a face mask, but a gentleman at the door told me that I could remove it when sitting on here on the stage. During the court proceedings, where I was investigating the decision in 2016 in the column room. First of all, it was open proceedings, and during the proceedings, I was supposed to reveal the information from the preparatory proceedings, which was aimed to prevent the prosecutor to continue the penal proceedings. So I am accused of Article 241 of the Penal Code. This is a crime which may entail the sentence of 2 years imprisonment. I did not commit a crime because the Polish penal procedure in the Code of Penal Procedure states that proceedings can be open, that audience and media can participate in it. And during such proceedings, the court cannot commit the crime based on Article 241, otherwise sentences could not be justified. There was also the prosecutor participating in the proceedings. She did not object to it. She admitted to conduct open proceedings. Then, in one of the decisions of the Disciplinary Chamber, an excerpt from the act was quoted. It was against me, and based on the prosecutor's hearings, it was clearly stated that my decision did not jeopardize the future penal proceedings. The so-called Disciplinary Chamber in November 2020 made a decision to discharge my immunity and to suspend my judicial service. Currently, penal proceedings is carried out along with the proceedings in front of the Disciplinary Chamber to take me by force to the prosecutor's office for a hearing. It was an application submitted by the prosecutor to the Disciplinary Chamber. Initially, the chamber denied. The prosecutor filed another application, and that's my martyrology in short. So, what do you do to come back to your work? Similarly to Judge Juszczyszyn, I submit requests to allow me to fulfill my judicial service. we also appeal to them to observe the decisions of the common courts and the EU courts that allow us to come back to work. I am also active in the civics layer. I participate in many discussions, and I use the services of pro bono lawyers and I fight in common courts and labor courts to get a decision that would allow me to come back to work. It's hard to persuade you to talk about emotions, but I would like to find out what it is like when your colleagues issue decisions that are harmful for you. How do you feel? Citizens' fight and lawyers' fight to defend the courts has been going on for 6 years. That is the time where you can become immune to it. So I don't experience such a severe swinging of emotions as I used. My voice is trembling, not because I am about to cry, but I simply tried not to burst out laughing. I am quite a positive person by nature, which I hope shows. If some decisions are issued against my will, and if on the media I can hear politicians talking, I'm interested to listen to them. Sometimes when I observe how nervous they are, I feel a lot of sympathy towards them. I'm also nervous during public speeches, and that's what it looks like. And if you hear such the title of our discussion, an able and autonomous Temida, Utopia or a self-evident civil right, how do you feel? I'm serious, and I am convinced that we can have independent and effective courts, judicial system, which is included in Article 45 of our Constitution.
I am convinced that it is possible and that all of us are fighting for it, both the lawyers and citizens. And before 2015, the judges and lawyers had various ideas to make the work of Polish courts more effective. Unfortunately, the politicians hardly ever listen to practitioners. It's true not only for the judiciary system. We can observe a similar situation in the healthcare system. The voice of physicians, nurses, paramedics is not heard by the government. Politicians prefer to fight against the court rather than to reform them. You are not the only judge. There is Paweł Juszczyszyn, Judge Wróbel, Judge Żurek, and many other judges. Do you feel that the other lawyers support you? Is this just that they are telling you that they are sorry and that's all? Of course, there are also our colleagues who attack us, but citizens and lawyers support us, and their support makes our situation better. Support of the people is most important, and the common fight together with the citizens to have the just judicial system. And if not the citizens, if not their protest, we wouldn't have the autonomous courts. And there is also support by IUSTITIA Association. They are great. Please visit the stand of this association. They also have a website. They have just published they published a report 2 years ago. It's called Judges Under Pressure. At the time when it was published 2 years ago, it contained 300 pages. I think when it's updated, there will be many more pages because it will include many other judges who are under this pressure. I wanted to ask you about this understanding and support of Polish people. Do you really have this feeling? Polish people support and they understand what is happening to the Polish courts, or maybe this is all the time the same group of people who are from association of judges of the Committee for the Defense of Democracy. But on the other hand, there are these people who are displaying posters which are showing you as thieves of sausage. Well, what have I been stealing? I can't remember. Well, we have to be open. There are 10,000 judges in Poland. And just like in any jobs, we have black sheep too. So the judges who violate the law and who commit common offenses, they should be deprived of the right to do their jobs. For example, Zbigniew M. Ziobro is an example. So I can answer your question by saying whether the three people with whom I was meeting in 2015, whether these three people are still coming, whether our hair has the same color. I think that the awareness of law in the Polish society is increasing, and this knowledge is also increasing. People all the time organize law-related cafes. Citizens arrive to such meetings. Very slowly, the number of young people is also increasing. I wouldn't like to advertise, but through the Constitution by Robert Hołda shows that people want to talk about the Constitution, not only about courts and the rule of law, but they want to talk about their rights. And I think it's optimistic. I wanted to ask you about the Constitucja. I wanted to ask you who arrived to these meetings and what people were asking you about. I understand that they wanted to meet with you. They wanted to look at the independent judges. What was important? What do they need? So who was coming? So Robert Hołda was there. I was there. I'm sorry that Robert is not here. Tour the Constitution is a civic initiative. It's organized for citizens, by citizens. Lawyers have lawyers-assisted organization. If we were able, we answered questions asked by the citizens. It was a civic initiative, and the courts were not the key topic covered during the tour of Constitution. People were talking about Constitution. Of course, some topics were raised, some topics concerning courts, and then we, the judges, were trying to explain who was participating. People who are interested in the situation in Poland, people who are aware that the rule of law is violated. There were people who are skeptical about the constitution, and we also saw people with whom it was difficult to initiate a dialogue because their participation only included swears, offensive language. Well, this is the nature of such meetings. These meetings are open to everyone, and constitution was something that joins us, not divides us. So it is just focused on dialogue, on talking. I would like to promote this initiative. Now it's called Tour the Constitution. The request stop. Please take part. Well, if you have any questions to Judge Tuleya, please get ready to ask them. I would like to get back to the first question, seriously. Temida, able and autonomous. This is the civic right, or is this a utopia? There is one answer, but can you see the moment when Temida will be able and autonomous, and Temida will become our reality? Well, this Temida is the civic right. It results from the Article 45 of the Constitution. So all of us, not only the citizens, judges and lawyers, want to make sure that then when cases are filed in the court, they should be completed quite soon. But it's not a factory. If you have a complex case, the court will not be able to settle it within 1 hour. And it's good that it's not happening so quickly, because then it would be quite easy to make mistakes. Lawyers have always worked to make these procedures more efficient. After the year 2015, there were 2 congresses of the Polish lawyers. During the first one, we have established some task forces that work on amendments of the procedures. But as I have said, politicians, especially nowadays, hardly ever listen to lawyers. So if we can, we issue our opinions on the legal acts developed by the parliament. Unfortunately, the opinion of practitioners, of lawyers, is not really taken into account. I do hope that it will change. If you listen to teachers, doctors, lawyers, then the law on education, on courts, and on healthcare would be much better. So now you can ask your questions. If you would like to ask a question, please raise your hand. Good morning, Anna Andrzejewska. I have a question. Before we had a meeting concerning the discussion whether we need a new constitution. What is your opinion? Do we need a new constitution, or we should amend this current constitution, or should we just observe the current constitutions? Wow, you have caught me. When there was the previous panel, I was having a beer. I don't know what Professor Bodnar and other panelists said. So I will be prudent and I will answer your question as a true lawyer. It's a very important question. Thank you very much for this question. I wouldn't create a new constitution. Undoubtedly, this constitution has to be amended. We need amendments that should be introduced in more peaceful times. These amendments should involve the following. The Constitution should have a provision on autonomy of the prosecutor's office. When we compare judges to prosecutors, well, judges are not really brave. Autonomous prosecutors are really brave. And the Constitution has no provisions concerning the prosecutors. So the Constitution should be amended, and this autonomy of the prosecutors should be added. A gentleman in the third row. Okay, somebody in the back rows. Joanna Koba. I have a question. Many young judges, solicitors are starting to work. They graduated from university several years ago. So what would you tell them? What would you tell them about now they are under pressure of the ministers, of the state public prosecutors? What would you advise to young solicitors? How would you add courage to them? Okay, I would like to answer the question nobody has asked me yet. Young people often ask lawyers during such questions. They ask us whether it's a good idea to become a prosecutor or judge now. And I tell them, yes, do this. You have to learn. You have to get education because you will be responsible for fixing the world we will leave. When we are talking about lawyers who already work in the judicial system, I can only say that the prosecutors' independence and autonomy, judges' autonomy and independence is something which is of key importance. And if we are not autonomous or independent in one case, then we will lose it. This will be a long-lasting damage. So if we work against our oath, we will wear the handcuffs on our hands ourselves, and we will have to wear them until we die. So we have to keep fighting. Well, there can be no compromise.
Dzień dobry, panie sędzio.
Good afternoon. There was a question about the new constitution. We have a division into courts and tribunals. So I would like to ask you about your preferred control of constitutionality. We have a centralized model, and there are three concepts that Szymon Hołownia mentioned. We can either liquidate the tribunal and implement dispersed control. We can leave it as it is and replace the current judges with the correct ones, or we can introduce control by the Supreme Court. From the point of view of the performance, would you prefer? Which one is most appealing to you? It's hard to say that we have the Constitutional Tribunal nowadays and that the thing that works in Aleja Ujazdowska fulfills its function. So we do have dispersed supervision, but such an institution as Constitutional Tribunal should operate, but it should be an independent court with autonomous real judges. Let's say there is election and opposition wins. What to do with the judges nominated by the National Court Council? The later we do have the election, the more judges we'll have. There are not so many of them nowadays, but if the election is held according to the schedule, it can be quite a significant number. The way and mode of appointing judges nowadays, when we have neo-national court council, is challenged and noticed by the European Tribunal of Human Rights and the European Court of Justice. There are different ideas how to handle it. For instance, these people should reapply for the competition for judges' positions. There are some ideas not to challenge or adjudications that they issued during their terms of office, but citizens should have an extraordinary measure that they could use if they consider that not the proper court was adjudicating in their case. However, the people who violated the rules should bear the responsibility. If we come to terms on what is going on nowadays, we won't be able to change anything. We won't be able to change nothing for better. The people who consciously participate in the nominating procedure, which is defective, it is demoralizing for the whole milieu. So I'm afraid that if the problem is not solved, it will reappear over and over again, and we'll have a similar situation in a few years' time. So we should draw, so a method of drawing a thick line won't work. However, there are various ideas, starting from the radical ones of removing these people from their positions, through to those which are less severe. The youngest lawyers are treated in different ways. I refer here to those who are currently in their training period and who will be nominated for the first time as judges. So we differentiate between those who are only assistant nominee judges and those who are those already working. That's a different approach to young people who are assistant nominee judges applying for the position of the judge in a district court. Could you put your hand up? Okay, we have some questions. We talk a lot about adding different articles to the Constitution, but I would like to ask about what should be removed from the Constitution, because there are different pathologies, such as offending the president. What would be the priority, to extend, to broaden, or the Constitution, or to skim it, rather? Or is it a problem at all? Well, I could refer to my favorite saying that it's easier to make a stick thicker than to make a thick stick thinner than a thin stick thicker. So first of all, every citizen should understand this document. This is the basic law that should not contain as many regulations as the Code of Civil Proceedings or the Penal Code. Is it possible to include all our laws and regulations and describe all major institutions in a thin document? I believe it is possible, but Constitution should not be an act of law composed of thousands of articles. If we are to change something, it should be done in such a way that an act of law which is quite limited in its range, but include all basic laws that do not raise any concerns or doubts as for interpretation. And if the regulations are interpreted, the analysis should be done in a fair way and according to the spirit of the Act, in order for us to live in the state of law and not in the state where a law is used in a subjective way as a stick, as a rod to beat somebody. Good afternoon. I would like to ask you, as the judge of Circuit Court, what do you think about such an institution as the Courts of Peace? I don't think that's the best moment to introduce something like magistrates' courts. Magistrate judges, is this a good idea or not? To me, such judges will be like the stick to beat street opposition. So we'll have a similar situation as we used to have in the communism. According to these ideas, the magistrates court judges among the group of people who voted for reassumption in the parliament, magistrates court judges are supposed to deal with petty crimes and civil breaches, minor or misdemeanors. So if such cases are filed to courts, they are mainly related to the penal code. The people working for the magistrates court don't have to be lawyers by education. So I'm afraid it would be another weapon against those who defend the rule of law. I am an advocate of letting the citizens participate in the judicial proceedings. I think that the jury is extremely necessary in courts, as they can affect the decisions of courts. In common courts, when we have juries, and the opinion, the voice of the juror is as important as the opinion of the judge. But in the period between 2005, the jurors were removed from the courts, and it was explained by savings. Now, when the ruling party mentions the institution of the judges of the magistrates' courts, that it's because they want to give the voice to the citizens, because in 2005 and 2007, they removed the citizens from the district courts, and that's the way it is. Please remember that the magistrates' court judge will be capable to deprive somebody of freedom or sentence to imprisonment for 30 days. Good afternoon, Marcin Adamuszak. Listening to the panel today and yesterday's panels, one conclusion comes to my mind. The basic law, namely the Constitution, did not defend us and will not defend us against anything. What happened in Berlin in 1933 is a testimony and consequence. It can happen everywhere and in every country. The system can be changed from the Franco system to the royal one. Took place with maintenance of previous institutions and went nearly seamlessly. It can also happen to us. So the debate about the abolition or lack of abolition is a similar thing. But I would like to ask you a specific question. We trusted the EU system. We trusted that it would protect us, even if we are not capable of dealing with problems. Since you have ability to adjudicate in a favorable way, but it's somehow blurred. Don't you think that the protection of the European Union is weak, it's soft, and now only it is about making money and dealing with economy than protecting our rights and our goods? In my opinion, it's really blurred. What is your conclusion in this respect? I am a crybaby by nature, so when I evaluate the operation of the European institutions, I use some critical words that these institutions operate too slow and they are not decisive enough. It must not be that the decision issued by the European Tribunal in July and an application is made for an explanation. The explanation is submitted within a month's time, then they are analyzed for a few weeks. The European Commission makes another step. From my point of view, it does not really look serious. It is not the case that I no longer believe and trust the European Union, or I no longer feel a European. That's not true. It seems that what is happening in our country for the rest of the European Union is also something new and is quite surprising. For 6 years, we have been learning how to defend the rule of law, and the European Union is learning on our example how to defend it. We are learning faster. The European Union and European institutions are learning slower. But Professor Sadurski analyzed the issue in one of his latest papers, telling that we should not lose our trust in the European Union. That's the way it is. The European courts are not the fastest ones, but they operate slowly but issue well-considered decisions. So we should not lose our trust in being Europeans. It seems to me that the European Union can also learn a lot from us. For instance, how to fight for the rules it talks about. And based on our example, it can see that it's not enough to talk about some values, but we have to fight for it. That's something we can teach the European Union.
Więcej pytań.
Unfortunately, we can have no more questions because we have to close the discussion. I've got one question. What can you hear when you hear the preamble to the Constitution by Jerzy Radziwiłowicz? And the second question, have you ever thought, well, I'm going to give up being the judge. I've got enough. Even when I am during the tour of Constitution and I hear the preamble for the 90th time, I'm always moved, especially when Jerzy Radziwiłowicz reads it. The preamble is very important. It has everything is in the preamble, in the second question, have you ever considered quitting being a job of the judge? No, I have never considered this. That's it, full stop. Judge Igor Tuleya.
It's not always easy to recognize. It may look like this, or like this. It may be a burden, but it is a responsibility that we embrace nonetheless. But if it means this for one person and this for someone else, maybe it ultimately means being there for one another. It isn't handed to us, but we know where to find it. And how it feels, how it tastes, and what it sounds like when we finally have it. It means different things to different people, but for many, it means everything. And if we all fight for it, it will eventually bring us together.
Now, warning, flight 1215.
You may now kiss the bride.
Work is different now. We're commuting less, virtually meeting more. Separating work life and life can feel challenging. It's easy to forget that to thrive at work, we need to take care of ourselves. Microsoft Viva Insights offers new experiences to balance productivity and well-being. Personal insights help you stay at your best and most productive. Add structure to your remote workday by opting for a virtual commute, carving out time to have a productive start in the morning and mindfully disconnect in the evening. Protect time before your calendar fills up for focused work, coaching, and learning. Take regular mental breaks with Headspace, tapping into dedicated moments of mindfulness. Use emotional check-ins to tune into your day-to-day mindset and well-being. Strengthen team bonds with Stay Connected experiences that prompt you to praise collaborators, schedule one-on-ones, and follow up on pending commitments and outstanding tasks. Insights for managers and leaders offer windows into how work happens and the impact on employee well-being. Identify where teams may be isolated and take action to break down silos. Quickly discover opportunities to prevent burnout, promote coaching and development, and boost engagement. You and your team's well-being is important, especially in times of change. Taking care of one another allows you to thrive and your organization to build resilience. Experience how new well-being insights in Viva can help.
Liberté Talks to co ważne. Seria Liberté Talks realizowana jest dzięki wsparciu Google oraz Państwa darowiznom. Na podcast Rozmowy Nienormatywne zaprasza Joanna Łopat.